As an elder law attorney, a question that we are asked often is what happens when someone has dementia and has no power of attorney? The answer to that question is it depends. On what exactly? It depends on really what level of capacity this person has. So having a diagnosis of dementia alone does not mean that this person can no longer execute documents or could not sign a power of attorney. But whether or not they understand what they're doing is what will determine whether or not they can actually do it. So if we have an individual with a diagnosis of dementia, but they still understand what's going on, they understand who their family members are, they understand what they have, and they're still in a position where they can direct other people to do things on their behalf. And most importantly, they understand the weight of what appointing an agent will mean, what their actions will ultimately mean, then they're perfectly fine and could still execute a power of attorney, hopefully sooner rather than later. But if they have a diagnosis and they are confused, they no longer know their loved ones, they no longer understand what they have, they're not really in a position to direct others on how to manage their affairs, then a power of attorney may not be an option. At that point, guardianship through a court may be the only option left. So is dementia the end-all be-all as far as getting a power of attorney? Not necessarily, as long as the person has the requisite capacity. If they do not, however, it's a little bit too late.